2017 CF 15684, State v. Nelson, back from our recess. Ms. Hicks, have you had an opportunity to review the modified 3.12D?
Yes, sir.
All right. Ms. Simmons, any additional argument?
No, just I provided a reworded version just as an example of how it could be clarified for the jury and less confusing. But I don't have any additional argument.
All right. Ms. Hicks, any additional argument?
Yeah, it's not legally correct.
Can you be a little more specific so I can ask Ms. Simmons?
The first sentence is, if you find beyond a reasonable doubt that the state has proven first-degree premeditated murder, then you may disregard this instruction. They don't, as we've been talking about all afternoon, they don't have to unanimously find that. And so if there's some juror, like, that absolutely suggests to the jurors that they have to find unanimous one or the other.
Okay. Ms. Simmons, reply.
Judge, just that, I mean, I would renew the previous argument about the fact that we disagree with that law itself. So, but I have nothing else to add.
All right. Is either state or defense aware, no one cited to me, but a case dealing with a request for this legally in some form or fashion, a legally interacting instruction? Yes, it can be given. No, it shall never be given.
Well, Judge, if you look at the jury instructions, it actually cites to a case and it talks about why this is part of the standard instruction at this point. However, as I said, I have in several cases successfully argued to keep this out. It's never been overturned on appeal. And I'm sure it falls. I didn't quite honestly do the research in the last few days to see if there's been anything new since the last time I did the research on that. This is a relatively new standard instruction, I would say, within the last year or two. And so, the answer to your question is I did not do any research on that issue. I think it really just comes down to, it's going to be very case specific about why this instruction shouldn't be given. And this is a very unique case about why it should be.
Ms. Simmons, any cases that you located, any appellate decisions addressing this issue supporting your argument?
No.
All right. After considering what's been presented to the court, I'm going to deny the request for this modified 3.12D legally interlocking count. I understand the defense's disagreement with the laws that exist, but one of the bases for the court's ruling is the fact that the laws that exist, I do not believe that this first-degree murder count is what is intended to be falling within the purview of the legally interlocking count, specifically because the law allows the jury to find, as has already been discussed, on either theory. That really distinguishes it from the, what we'll call a sole felony murder theory that the state referenced in its argument. In addition, because of that law, I agree with the state that portions of this instruction do not accurately reflect the law. And then additionally, because of these same issues, I think there's a substantial danger of jury confusion by adding this additional instruction. Given that the instructions as prepared clearly instruct the jury that as to the two different theories that the state can proceed on first-degree murder, that is premeditated or felony murder, clearly instructs the jury that if they are going to find under the felony murder theory, that they must find that the state proves element 2, which all of the specifically enumerated felonies that the state is relying upon for the felony murder theory, and then each and every one of those is clearly defined and is referenced at the bottom of the instruction that they are defined for you below, which sets forth in detail all the elements of each and every enumerated felony, count 3, count 4, and count 5. And I think to add this instruction would have a substantial danger of confusion. Without it, I think the jury is clearly instructed what they have to do if they are going to find that the state met its burden with respect to the felony murder theory. So for all those reasons, I'm going to reject the defense's request for this modified 3.12D instruction. So that means with this draft that we've been talking about, that 3.12D can be removed, as well as that reference in I think it's 3.12A.
Correct.
Yeah.
Judge, I just emailed defense counsel how I kind of edited the thing at the end about the stuff going into the operation room. It reads, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of the exhibits will be sent into the jury room with you when you begin to deliberate. However, exhibits that contain biohazardous materials or weapons cannot be sent into the jury room. If you wish to see any exhibits that are not sent into the jury room, please request that in writing.
That's acceptable, Your Honor.
I
Okay.
made that change as well.
All right. So let's print out what may very well be the final version that I would read to the jury.
Yes, sir. And I believe since we did not make any changes to the verdict forms, the ones that you have are.
Unless, are there any other issues that we need to discuss? Any disputes, any things that are missing, any things that need to be added that other than what we've already discussed and the court's already ruled on to the extent there was a disagreement?
Nothing to say, Judge. Nothing to say.
Are the courts reviewed the latest version of the jury instructions? It appears to reflect all of the changes that were discussed to the extent they were agreed to the extent there was not an agreement. It seems to reflect the court's rulings as well. Does the state see anything that still is in error, or maybe even something new that you discovered?
Mayor.
Defense?
Mayor.
Mr. Nelson, have you had a chance to review this latest version of the jury instructions?
I'm reading it right now, Your Honor.
Sure. Go ahead, please.
Okay, I'm sorry.
No, that's fine. Go ahead. Continue.
Yes, sir.
All right. Ms. Hicks, any objection from the state to what the court's holding here? You just reviewed. Mr. Lahr?
No, Your Honor.
Mr. Nelson, are you still reviewing the final version, or have you completed it?
I'm gonna, 1 second.
Mr. Nelson?
Yes, I've reviewed them with my attorneys, and I agree with them.
Okay.
Thank you, Your Honor.
All right. Has state already identified which exhibits are going to be held back, so to speak, here in the courtroom as opposed to being sent back?
No.
All right. Do we have are all the exhibits? I see some bin there. I don't know. Is that all the exhibits?
Court looks at, this is 129 in evidence. As an example, there's a neon orange sticker
Mm-hmm.
typically on surfaces of the item that indicate that it's filed. So anything that has that sticker, we would agree, should not go back unless requested.
All right, let me ask the clerks this. Do we have the capacity to separate these now and store them in two separate bins, if you will?
This is actually the Winter Park Police Department's bin, but that's not a problem.
No, yeah, I mean, just two separate, that way we don't have to worry about doing this tomorrow.
Yeah, we have a cart.
Okay.
Plus, there's also exhibits at the bottom that hasn't been admitted at all. It's at the bottom. There's a note that says not admitted.
Okay.
Maybe 15 copies of the jury instructions.
Yeah.
I need to bring 15 copies of the jury instructions, correct?
Nope.
You don't give each one?
No. What I read, that's what they get.
So I understand that, but
I don't,
typically, some people like to read and some people like to listen.
I don't give instructions to everybody because I don't want any chance that what they have is different than what I read. So what I read is what goes back with the evidence. Right, so in the bin, those are the exhibits that are going back with the jury in that bin?
Those are the non-biohazard exhibits, yes.
Okay. And then on the top shelf of that, I see several labels. Those are all the things that are going to stay here in the courtroom. Okay. And as well, the non-admitted marked materials, those are also in the cart that's going to stay. Okay. All right, does the state need any more time to check these exhibits here in the way we've segregated them?
No.
Defense?
No, no.
Okay. All right, anything else from the state before we go into recess for the day?
From the state.
I just have a scheduling issue.
Okay.
Judge, we just wanted to bring up again our issue with Dr. McLean. Now that we have a better idea that we will be starting the penalty phase on Monday, the state had said that they believe that their testimony will take either most of the day, but potentially not all of the day on Monday, so we may be putting on witnesses on Monday. We believe that we would have all of our other witnesses completed by about midday on Wednesday. So given that, we are asking the court that if that is the case, the court consider recessing so that Dr. McLean can testify in person on the 8th, rather than over video in the afternoon. We're having some issues setting up that because Dr. McLean is there on vacation and coordinating not only the normal things that go along with video conference, but her childcare, transportation, and any number of additional issues. So we wanted to ask the court if that would be something that you would consider so that we can ensure that Dr. McLean is able to testify.
All right, so you're requesting that Dr. McLean be permitted to testify July 8th?
Yes, I think regardless, we're going to go to the 8th, that it seems to be that way. That because the state is going to put on rebuttal evidence, that we would be in the 8th no matter what. So instead of her testifying by video, that is going to be extremely difficult to do on the afternoon of the 3rd, we're asking that potentially we recess early that day and then start with her testimony on the 8th.
Okay. Just so, again, so I understand, I guess, the timing as we sit here today, understanding things can change. If we start the penalty phase 9 a.m. on Monday, July 1st, then opening statements, then the state starts presenting the evidence. When does the state rest on its initial presentation of the evidence in the penalty phase, anticipated, just ballpark? That day or Tuesday?
I think Monday, barring unforeseen issues.
Okay. Late end of the day, you think it'll take the whole day on Monday?
Judge, I'm very reluctant to say beyond that, given experience yesterday.
Okay.
Put a gun shy after that. I would, if everything goes perfectly, I would think we would be resting sometime mid-afternoon on Monday. I have illusions that things will go perfect. So I don't know.
Okay.
Judge, I believe that once the state rests, we would have to make JOA type arguments as to the aggravators. So I believe at best, the defense would be putting on testimony late afternoon Monday, but most likely starting Tuesday. We believe that we would certainly fulfill Tuesday and Wednesday morning.
That's the point I'm trying to get. So even if Dr. McLean doesn't testify the week of July 1st, there are other witnesses the defense would call.
Yes, and we are planning to, that's our plan, is just, we have witnesses that will be flying in, start and expect to be here to testify either late Monday or beginning Tuesday. We have at least a full day, most likely a day and a half of witnesses excluding Dr. McLean. And so that's why we're asking that if we get to that point, that we can recess early on the 3rd and then just start with Dr. McLean on the 8th, who would be most likely our last witness.
Okay. So if we recess, then the only witness the defense would be calling during its presentation the week of July 8th would be Dr. McLean on July 8th.
We believe so, barring some, again, unforeseen issue.
Okay. And at this time, the state believes the rebuttal presentation would be what duration? Again, just ballpark.
Can't anticipate the cross. I would suggest if Dr. McLean goes a couple of hours Monday morning, I think we would conclude the state's rebuttal Monday, probably late afternoon.
Okay. All right. All right, so, like Mr. Nunnally, the court's somewhat gun-shy with the things that we've had arise during this course of this case. But my inclination would be if the defense is presenting its portion of mitigation on the 3rd, and then the only witness left is Dr. McLean, then the court, subject to change, would recess, and we would a long break until July 1st, or July 8th, excuse me, and reconvene
Thank you, Judge.
for the presentation of Dr. McLean, and then followed by the state's rebuttal. Okay?
Yes, sir, thank you. I don't believe there's anything else.
Is there anything else that needs to be done with respect to video conferencing? I know I signed the one order that would allow the defense, if it chose to present video testimony. I believe, Mr. Nunnally, you said maybe you would be doing that. Is there anything else I need to sign to get that ball rolling? Okay. All right. All right, anything else from the state before we go on recess? Defense?
That's all, Judge.
Mr. Nelson?
Oh, Your Honor.
I'm sorry, Your Honor, Ms. Hicks reminded me, we had provided an email to, actually 2 emails to counsel regarding one of the jurors whose son has a case as a victim pending at the state attorney's office. The court recalls that during the voir dire process.
Actually, I don't, but go ahead and refresh my recollection.
One of our jurors disclosed during the voir dire process that her son was the victim in a pending case.
I do recall that now.
Apparently, that case is set for court in the near future, and our witness coordinator not realizing that contacted the mother as the parent or guardian of the minor witness, and then she disclosed her service. And there was, to my understanding, no communication about this case. And the juror apparently was just making inquiry at if somebody else besides her could take the child to court. So, we disclosed that to the defense, that this happened, and I've been told unofficially, perhaps we get on record, that they've discussed this matter and have no issue with my disclosure or what occurred.
What's the juror number of the person we're talking about?
I'd have to see the list.
Last name Crab.
It's,
Most of the names on the record.
yeah. Here's the, let's see. The jur-
I
Yeah,
can look at the,
mine's like a mess. Do you have like a clean list, Ms. Madam Clerk?
juror number 254.
254.
Seat 7.
Now, seat 7 is 5159. Seat 3 is 254. Okay,
Seat 3. Okay,
Seat
I was
three.
looking at,
Juror number 3.
right, seat 3, 254. Okay.
Judge, we agree, we had, that they provided that disclosure, we just, Mr. Nelson, we have no issues.
Mr. Nelson? All right. You heard what Ms. Moore said and what Ms. Burdick said? No issues? Okay. All right, anything else from the state before we go into recess? Defense? Mr. Nelson? All right, we'll be in recess till 9 o'clock tomorrow morning.